Well, breaking a franchise agreement versus getting a resolution or a settlement to get out of the franchise agreement are very different and also very important. Because if you breach a franchise agreement, many franchise agreements have a liquidated damages provision in them. And what a liquidated damage provision says, if this agreement is terminated early, then you're going to pay a liquidated damage, a dollar figure of a certain amount. And that is usually calculated off what the royalty payments would be for the remaining period of time of the franchise agreement. Also, another thing to be very conscious of is whether or not a personal guarantee was signed. Because most franchise agreements, we always recommend that the franchisee enter those through a limited liability company, an LLC. But most franchise agreements also require the franchisee to sign a personal guarantee. Many of them even require the spouse of the franchisee to sign a personal guarantee. And so if you've signed that personal guarantee, even though you have the franchise in a limited liability company, there's still personal liability on it. So that's one of the things we look to when we review franchise agreements as to what are the terms of that guarantee? What do we need to do to limit that guarantee? How do we protect you individually when you're entering into this franchise agreement? And another consideration upon breaching or terminating a franchise agreement is the non-compete. So let's say you breach that agreement, but you've got a lease on a facility, a warehouse, an office building. And if you have a non-compete that says you can't within the territory provide the same or similar services, then what are you going to do with that lease that you've probably also got a personal guarantee on? So there are many considerations that we need to look into before the decision is made to simply close the doors and breach the agreement. What is our personal liability? What's the long-term impact on other liabilities that we might have?